Today, the topic for discussion is clauses of Memorandum of Association and their alteration. The definition of Memorandum of Association has been provided under Section 2, Subsection 56 of the Companies Act 2013. Memorandum means Memorandum of Association of a company as originally framed or as altered from time to time in pursuance of any previous company law or of this Act. This is again a limited definition of Memorandum of Association. Though Memorandum of Association is considered as the charter of the company, it is the main document which lays the foundation or the basis for formation of the company. It is the limit within which the company needs to function. It contains various clauses. The various clauses of Memorandum of Association are name clause, registered office clause, which is also known as the situation clause, object clause, liability clause, capital clause, subscription clause, and in case of one person company, we have got a nomination clause. Now, getting into the details of each clause separately. Name clause. Name clause contains the name of the company. The name of the company must be pre-approved by the registrar of companies by applying for the name as discussed in case of formation of company. The same name must be adopted by the company as its name. The name must be unique, it must not be non-desirable, and it must not be prohibited under any legal acts which are for the time being in place, in force in India. In case of public company, it must end with the word limited, and in case it is a private company, it must end with the word private limited. Next clause is the registered office clause. Registered office clause mentions the state in which the registered office of the company is proposed to be situated. The detailed address of the company's registered office is not required here. This is made for the convenience that in case the change in registered office happens within the state, no change or alteration of memorandum is required. That we will discuss later. Next clause is the object clause. The object clause is divided into two parts. The first part contains the main object. Main object is the main object for which the company is formed, and next clause is the other objects. Other objects includes those objects which are not included in the main object, but the company has thought that this objects will be pursued by the company in the near future. Next is the liability clause. The liability clause states the extent of liability of the members of the company. The liability clause or the liability of the members may be divided into three parts. It may be liability limited by shares, it may be limited by guarantee, it may be unlimited liability company. If it is limited by share company, that means the members are liable to pay only the unpaid value of the shares which are held by them. In case it is limited by guarantee, at the time when they become member of the company, they are to get into an undertaking with the company that they are agreeing to pay a guaranteed amount at the time the company goes into winding up. This amount needs to be paid only at the time of winding up and not during the operations or during the lifetime of the company. Guaranteed company can again be of two types, that is companies having share capital, companies not having share capital. If it is a guaranteed company having share capital, the shareholders liability or the members liability will be twofold. One is for the guaranteed amount which they have to pay at the time of winding up, and the second part of the liability will be unpaid value of the shares which they are holding. In case it is limited by guarantee, not having share capital, the liability of the members is only one-fold, that is they have to pay only the guaranteed amount at the time of winding up of the company. If it is an unlimited liability company, the liability of the members of such company is similar to that in case of a proprietorship firm or that in case of a partner of a partnership firm. These companies can again be of two types, having share capital, not having share capital. If it is an unlimited liability company having share capital, liability is twofold, unlimited liability of members, and second, unpaid value of the shares which is held by them. If it is unlimited liability company not having share capital, only one-fourth liability is there, that means the liability is unlimited. Next clause is the capital clause. Capital clause states the amount of authorized share capital of the company. Authorized share capital is also called as nominal capital or the registered capital. All mean one and the same thing. This is the maximum amount of money which the company can raise by way of share capital during its lifetime. The next very important clause is the subscription clause. Subscription clause is basically the clause which gives the legal effect to a memorandum of association. When members come together and they agree that under this name, under this situation and in this object, with this capital and liability we are agreeing to come together to form a company, then the company gets formed. Subscription clause has got that effect. So subscription clause is also called as association clause because it has got the impact of creating an association. In case of a public company, minimum 7 people must sign the association clause. In case of private company, minimum 2 people must sign the association clause. This people who sign the association clause are also known as the first members of the company or subscribers to the memorandum of association. The last clause in this discussion is the nomination clause. It applies only in case of one-person company. Since in case of one-person company, only single person is the member of the company. In case anything happens to that person, who will take care of the workings of the operations of the company in the future? For that, we have got a nominee who is to be appointed by the one person on a compulsory basis. The nominee must be such a person who is capacitated to contract. That means he must not be a minor, he must not be of unsound mind and not be otherwise disqualified to become member of a company. And the consent of the nominee must also be obtained. So this is the nomination clause. This was all about various clauses of memorandum of association. Now moving on to how these clauses can be altered. As we all know that memorandum is very important document of the company, and if frequent alterations are allowed, that will defeat the basic purpose for which the memorandum is prepared. For that, alteration of memorandum is not an easy task, and foremost for altering any clause of memorandum, first condition is a special resolution of the members must be passed. Special resolution, we all know, that means that if 3 members have voted in favor, only 1 can vote against, or we may say 3/4 majority is the special resolution which needs to be passed for altering the memorandum of association. Separate procedure is there which is prescribed for separate clauses of altering the memorandum of association. Let's take up alteration of name clause first. For alteration of name clause, the members must first approve the alteration by passing a special resolution. Then this new name which has been proposed must be approved by the registrar of companies, and then a prior approval of central government needs to be taken. After this consent is taken from the central government, all these documents, that means prior approval from the registrar of name, then the special resolutions copy and the permission of central government needs to be filed to the registrar. The registrar will cancel the old certificate of incorporation and will issue a fresh certificate of incorporation in the name of the company, and that's how the name of the company can be changed. However, the procedure is different if only that is the question of change of name involves adding or deleting the word private from the name. That we will discuss in later videos. Next, alteration of memorandum involves alteration of the situation clause. As we had already said that the memorandums or situation clause or registered office clause only states the state in which the registered office of the company is situated. Thus, if the change of registered office is within the state, no alteration of memorandum is required. Alteration will be required only when the change is from one state to other state. So for this, the company needs to pass a special resolution, and then it needs to take prior approval of the central government, who will grant such approval on taking into consideration the interest of the creditors. Then after the consent is granted, if again 2 aspects can be there, the change could involve change from one registrar to other registrar, or the change could involve within the same registrar. For example, in Northeast we have got the registrar office in Shillong. Suppose the registered office is situated from Assam to Meghalaya. Though the state is changing, memorandum needs to be altered, but in this case the records of the company will stay in registrar office of Shillong, because for Assam and Meghalaya both registrar office is at Shillong. So thus, in case of such instances wherein registrar's jurisdiction is not changing, the procedure completes when the approval of central government is given and the documents are filed with the registrar for registration. In case the change involves change in registrar's jurisdiction as well, like change from Assam to Delhi, in that case the change needs to be registered in both the offices. That means the records must be transferred from registrar office of Shillong to registrar office of Delhi. For that, an application needs to be made along with attaching all the necessary documents from whom the permissions have been obtained, and then the record of the company will be transferred from Shillong office to Delhi office, and a new certificate of incorporation will be issued by the registrar office of Delhi, and the old certificate of incorporation will be cancelled. Next is the alteration of object clause. Object is the foremost thing or the most important thing for which the company is formed. And if frequent change in object clause is allowed, that again defeats the basic purpose for which the company was formed. So for change in object clause, special resolution is required, but the special resolution is a special category again, because this special resolution needs to be passed by postal ballot and not by holding a general meeting of the company. So in postal ballot, more participation of members is possible, and that's why we can say that such special resolution we will have more consent, considering or comparing it with any other meeting. Then an advertisement needs to be published in 2 leading newspapers of the state in which the registered office of the company is situated. The 2 leading newspapers must be, one must be in English, other must be in the local or the vernacular language. Then dissenting shareholders, if any. That means if the money which has been given by the shareholders for investment in the company as share capital, if that money remains unutilized and if there is any dissenting shareholders who does not approve such change, the money of such dissenting shareholder must be refunded and the shareholders must be given an option to exit. When this process completes, after that the necessary documents is filed with the registrar for registration and the process completes of change of object clause. These are the main alterations which we must discuss in relation to Memorandum of Association. Memorandum of Association, once again I repeat, is a very important document of the company. And that's it for today. If you have got any doubts, you can mail me at the given mail ID below. Thank you.